A warm welcome to all of you, our viewers, on the edition of The Link this week. We always promise to give you information that you can use and opportunities, and we try to keep that promise. And we have, I have met some of you out there, and you have shared your experiences, which is very, very encouraging for us to keep us on a trajectory. We're doing the right job, I believe. And thank you for the feedback. Tonight we're discussing a topic that you may not have encountered, but it is something that you should know. We're discussing competition. Uganda has a new competition law, and it's now in effect. Passed a couple of years earlier, but not actualized, but now it is in play. And if you're in business, these are things you ought to know. And tonight I have the right person to tell us about this new competition law, Miss Mercy Odu. She's a corporate and finance lawyer. Mercy, welcome.
Thank you very much, Solomon. I'm so glad to be here.
We appreciate you giving us your time to come and teach us. Let's take the first question. Take us through the key things in Uganda's competition law that if I am in business, I must know.
Thank you. And that's a very good question.
Yeah.
But before we get into the Ugandan competition law, I think it would be a good place to start with, from a place that we can all relate.
Absolutely.
And that's to understand the concept of competition itself. Competition in the sense of business is that there are two or more businesses competing for the same market segment, same customers, same goods, same products and all.
Yeah.
So competition is about managing markets. It's about managing how businesses and the consumers interact in the marketplace, essentially. Okay. So to give you an example that someone might relate with, you have a group of bakeries on Ginger Road, and they're selling fresh bread to the market. And they're all selling the same product to the same market segment. Competition is, for healthy competition, is that if one of the bakeries decides to offer fresh bread at a price less than what everybody else is offering, and maybe decides to open earlier than the rest of the bakeries, and maybe decides to also include an element of delivery to its customers, what that does is then it will force the other bakeries on the same street to adjust, right? So that they're able to also compete fairly in a healthy way. The beauty of such healthy competition is that the consumers have choice. Consumers have access to reasonable price, and the businesses are also forced to innovate. So healthy competition, very good. Okay. The opposite of that is assume the same bakeries sit down one morning and say, we're all going to open at 10 a.m. Okay. And we're going to offer, no one is going to offer bread for less than 5,000. Okay, they're fixed a price. They're fixed a price for the market. What that does is taking away from the consumer choice. It's taken away from the consumer fair price, and it's taken away from the bakery business innovation, right? And so the market suffers for it. So from a very basic level, that's what competition is about. Competition law is about regulating markets in which we operate and ensuring that markets are open and are fair. And so at the heart of competition law that we discussed today is market, it's fairness, it's openness, it's consumers, and it's the economy. Because when you think about the economy benefits from a healthy competition. Absolutely. If there's healthy competition in the market, there's going to be more investment because there's more money coming into the economy, because the economy encourages competition and businesses make money out of it. It's going to encourage innovation among the competing interests in the market. It's going to encourage industry, when you think about it from that level, that we're going to become more industrious and more productive in the way we engage with markets, which is good for the market again, from the business side. And then from the consumer side, choice, and then all that feeds into the economy. Okay. So competition law is about creating fair markets, and also the market keeping those dynamics alive daily, everyone checking the other, so that the consumer, who is the final person at the end, has more to deal with. Okay. So that's what competition is about. And so it's very good that we have in place a law in Uganda. So the competition law was passed in 2023, and the regulations were published just a month ago. So we have a whole regime, a whole framework now fully in place, which is good. So good step in the right direction. To answer your question, what are the three takeaways? For any business in Uganda, whether you are a fintech startup in Tinder, whether you are in Chikobo, whether you are a cement manufacturer in Hima or whether you are distributing goods from Malaba to Mutukula, whatever point of business you're doing, these laws apply to you in the same way. So one important thing that this law has done is to set out a whole array of prohibited behavior and practices.
Bad behavior.
What the law calls anti-competitive practices.
Practices.
And where do they start from? They start from agreements. The agreements that are anti-competitive in nature, where we shall maybe put, I'll say, I'm going to distribute to you water exclusively. So you have cut out any form of competition. That shouldn't be in it of itself bad. It's just the effect that happens in the market that is going to be now scrutinized to see what's the effect of this agreement to the market.
And the motive.
And the motive. So now that's going to come under scrutiny. So now we have prohibited behavior. Are you fixing prices in the market? So assume that the dominant fuel suppliers in Uganda today sat down and fixed the price for fuel. So it doesn't matter whether you're in Bushenyi or you're in Bukedia or wherever you are, you're finding fuel at the same price. That doesn't really help the market. You fix prices and you're doing a disservice to the market. And consumers now have to pay a high price without having so much choice to deal with. So anti-competitive behaviors have now been set out, and it would interest all of us in the market, business and consumers, to go and find out what those things are.
So that I can scrutinize myself and say, is what I'm doing against the law?
Absolutely. Am I compliant with the law? Or am I going to be found on the wrong side of the law?
Okay.
Very important. So that's one aspect. The second aspect that the law has introduced is the aspect of abuse of a dominant position.
Abuse of a dominant position.
By its definition, it assumes that they're dominant players in the market or different segments of players in the market, big size players. They have big tickets, big budgets, big infrastructure, they have it all. So they have that advantage and they can access bigger market segments.
Okay.
Now that shouldn't be a problem because it's not their fault that they have big budgets. It's just that the effect of that might be that because of that access they have an effect of aging out smaller players who might, if they had similar access, would be rivals.
To discouraging competition.
To discourage competition and to have more markets entry. Or it might be a case that they have access to infrastructure upon which other smaller players can peg on also to offtake, right? So it might be that they might put artificial barriers to accessing such infrastructure, and so the smaller players will not be able to afford it, and they'll just go away. They fizzle out, they die. Or those who try, they might put in some restrictive clauses in agreements that make it just so hard to comply and to access that, and so it becomes very restrictive and anti-competitive. So now the Act has a full regime about just what is the dominant position, who is the dominant player, how do we...
They define who that
and
person.
the regulations now that have come in now say this is dominance, this is the threshold, this is the percentage. So all that is now in place to guide the market on what that is, and so abuse is also now quite defined, right? And thirdly, the third takeaway is merger regulation. Merger regulation. So I'm a lawyer in corporate. I advise on mergers and acquisitions all the time. And you're merging, you're acquiring a business. That in itself is not the problem. The problem is the effect of that merger in the market. So if the merger is going to edge out smaller players, that's going to be scrutinized. So now the law requires that any companies, any businesses that are merging have to notify the authority or get approval. And the regulations have now set out thresholds of if your merger is this threshold in value, that is going to you now require approval from the authorities. So it's not every merger really, but there are thresholds now in the law that provide that if your merger is of this value, get approval.
If I, Sam and company, I'm going to acquire Ibra and company, now it requires me to notify the authority that we are going to do this, and then they can say you can go on. Can they say I can't go on? Yes, they can say you can't go on because they're going to assess the effect of that merger to the market. So let's take an example of commercial banks. If two of the biggest commercial banks in Uganda today decided to merge, they're going to have it's a big thing. Yeah, it's going to have the biggest market share.
they will dictate price, they'll dictate services, they'll dictate everything.
Yeah.
And the smaller players or fringe players around the financial services space might suffer for it.
I'm imagining even fuel.
Even fuel.
I won't mention them, but they're big ones and they emerge.
Yeah.
The small ones are dead.
That's it, right? So those are the kind of effects that the authority and the law are now going to be very keen on in looking at the effects of these mergers. From a domestic level.
Okay.
Yeah, from a domestic level.
Thank you so much, Mercy, for that. We'll go for a short break. And when we come back, we're going to ask more on this new competition law. If you don't know it, you ought to know. And that's what we do on the link. We awaken you so you get to know and do more examination because we don't have all the time. We'll come back after the break and we'll continue with this discussion. Welcome back from the break, and we continue discussing the new competition law whose regulations have been recently passed, and the law was passed a little while ago. Mercy just explained to us in the first part. We want to continue with the questions here. Mercy, let me come back to you. What do you envisage to be key problem areas for businesses to apply the new law?
A very good question. Also because of the timing of it. You just mentioned that the regulations were published. The regulations were published just a month ago. So as far as this law and this framework is concerned, it's now entering implementation stage for the first time. Very nascent. And as you can imagine, when things are new in this kind of space, there are bound to be some teething problems. So not really problems as per your question, but in my view, things that we need to be aware of as businesses, as consumers, that might affect the implementation of the new competition regime. And I think from where I see it, I categorize it into three. One is capacity issues that we need to look out for. Two is risk of overarching or competing regulation or regulators. And three, and most importantly for me, is just knowledge or just the market and how the market is going to respond to this new law. So from the first one, the regulations and the acts have designated the Ministry of Trade, cooperatives and industry as the implementer of this law.
Okay.
And the regulations have also now set out that the minister will appoint a committee, a technical committee of 7. And that committee is really, it takes from government, private sector, and academia.
Yes.
The role of this committee is really to implement the act. And so the assumption is these people who are going to be appointed are knowledgeable and they have the necessary expertise. Competition is really about the economy. It's numbers, it's factual, it's data, right?
A lot of data.
A lot of data. What are the numbers saying? What are the numbers from BOU saying? What's the last census saying? What's the market dimension? Who is where? Where's the money? You know, where's the concentration of A, B, C, D? So many factors at play in every given point in time. So the idea about this technical committee and everybody working in the authority is that they're knowledgeable and they have the necessary expertise. I bring it up as a potential problem because we don't know if we will have all the necessary expertise to start the implementation. I think it's a good place to start. It's a good problem to have because what that means is that the authority has the work then to look out for all expertise in the country and bring them together.
I hope they will do that.
But also build it internally.
Yes.
It will be very important to have expertise because we're talking numbers, we're talking big business, big money that's going to be considered. So if someone is going to make a complaint that someone abused the dominant position, we are talking numbers.
Jobs, billions of shillings.
Billions of shillings. So that's one area to be concerned about. And you might ask, why would I be concerned about that if I'm a trader in Chikubo? You must be, because the assumption is competition law is not about big players. It's about all of us. You might be a trader in Chikubo, but in the Chikubo economy, you're the big guy.
So this law also pertains to me if I am in China?
Even
in a mall?
Chira, yeah.
Okay.
It pertains to even when you're a startup in Ntinda, trying to get your business off the ground.
Okay.
It should concern you because you need access to the market. And so those barriers to the market all come into play here. So anyway, capacity issues is one thing for all of us to pay attention to. The second one I had mentioned is a risk of dual regulation, if you like, because until 2023, we did not have an overarching competition law. What we had was sector-specific provisions of the law. So telecoms has, financial space had, UCC, BOU, energy space had provisions in their respective laws that provided for anti-competition or what would happen if you engage in anti-competitive behavior. But now we have an overarching law. So what will happen then if there is a merger in the telecom space, or if there's a merger in the financial
What will
space?
happen to those regulations which were there before?
Who will govern it? Will it be the regulator or will it be the authority? There needs to be clarity around that for purposes of implementation, so that there are no clashings or anything, but also so that the market is aware, where do I go? Who do I seek my approvals from?
Yeah, I see, for instance, in the banking sector, if it has happened, Bank of Uganda has a grip on the industry. And now we have Minister of Trade. So the argument is, who has more competence?
Who is it? I
see your point.
So ideally, that should be easy if they speak to each other and create that clarity for the market. But the final problem, Solomon, I need to highlight is us, the market. It's a new law, new regulations. Everything is new, right? So the regulator, the businesses, the consumers, all of us have to now start informing or teaching ourselves about this new, so that we know when to comply, how to comply, where to go, in case we have a complaint, what to do. So I think there's a lot of work to be done, which is exciting, really. There's a lot of work to be done to build from the bottom. Information needs to go out into the market and enlighten the market about this law. What is involved in it? What are your obligations under the law, and etc. A lot of information has to go. A lot of engagement and synergy and interaction has to go in between the authority, the minister, the businesses, the consumers. The professionals like us as well need to now educate ourselves about what this law is, because we've been advising in abstract to the extent there are no specific laws in that area. But now there is a law. So now there's a law, and we now need to also get into it and understand it, unpack it and understand it, so we can advise our clients better. Okay, very good. Finally, my final question. Uganda has been operating under the COMESA competition, what's called anti-competition or competition law, COMESA, Common Market for Eastern and Southern Africa. Competition Authority. And now we have ours. So what's going to happen? Let's say you have a merger or you have a business and it's cross-border, but it has jurisdiction also under our law. What happens in those cases? As it has happened before. Until now, if there was a cross-border dimension to any merger or acquisition, COMESA, like you've rightly pointed out, has been the place to go to. Because now what COMESA looks at is the effect on the region. What that basically means is that now we can focus on our domestic. And to the extent there's a cross-border effect, COMESA will come into play. There is a spanner. There's an East African Competition Authority that is going to start probably running anytime soon. So it's not going to be just COMESA. It's not going to be Uganda, East Africa, COMESA. So, but what that means for businesses and for all of us to know is that we will have dual or even triple compliance. That means I have to make all these guys happy. So now you have to make sure you're right with Uganda, you're COMESA, you're right with East Africa. There's going to be a need of a lot of conversation and synergy. I think just from COMESA to your question, what Uganda needs to do is to now have an MOU or have an understanding with COMESA to say, if a Ugandan enterprise or a Ugandan business is involved in any cross-border, these are our parameters. Are they the same in COMESA? How can we align them to make sure that compliance becomes very difficult. If Uganda is saying A and COMESA is saying B, it becomes a bit hard. To the guy who's merging, the guys who are merging. The requirement now under regulation is, if someone files a COMESA application, all they need to do is to notify the Ugandan authority for now. But what will happen when there are contradictory issues, conflicting matters? So I think those are some of the things that need to just be picked out. I think, again, it's a case of dialogue and understanding. Nothing a memorandum of understanding cannot fix, in my view. But then these are still steps that need to be taken. So what is the position of COMESA? It's cross-border, it's regional. Uganda is domestic, and both can work together.
Thank you so much, Ms. Mercy Odu, corporate and finance lawyer, for taking us to class on the new competition law for Uganda. It hasn't existed before 2023, and now it has regulations passed just barely a month ago. And that means if you're in business, you're going to compete with other people, there is a regulation, even for the consumers. In case there are people are doing things, businesses are doing things, and you think they're affecting you. That is something you need to pay attention to. We hope we added value to you on the link tonight. That's what we do best here. Thank you for joining us tonight.